All right, good morning. Let's go ahead and get started. Thank you so much for joining me today. Today, we are going to talk about how to file a Social Security request for review of an administrative law judge decision. This is also often known as the Appeals Council appeal. You are appealing an unfavorable judge's decision up to the Appeals Council, which is currently based in Falls Church, Virginia. So before we go any further today, I do want to remind everybody that today's webinar is not legal advice. I don't know the specifics of your situation. I am happy to answer any questions regarding the specifics of your situation if you give me a call or reach out to me directly. Will be instructions kind of at the end of the webinar on how to do that. But by and large today, what we're discussing is not legal advice. I don't know your specific situation. If you do have questions and you would like to seek legal advice, either reach out to a local attorney that you know around, or feel free to reach out and give me a call. As I'll talk about on the next slide briefly, Social Security is a federal administrative area. So it is something that it's the same across all 50 states at the administrative level, which does go through the Appeals Council. So it is something that I can discuss with you. I'm based in Florida, but if you're in another state, it's certainly a discussion that we can have, as Social Security laws are the same across all 50 states at the administrative level. They all follow the same rules and regulations. Okay, with that out of the way, here's what we're going to talk about today. We're going to talk about what's different about a judge's denial. If you've received a judge's denial, this is the third denial you've received on this application. What's different about it? I'm sure as soon as you receive it, you notice a lot of things that are different. The second thing we're going to go into is how you can file that request for review of an administrative law judge decision. Then we'll talk about what Social Security will do once you file your appeal. And then finally, as always, we'll talk about how an attorney can actually help you with your Social Security disability claim. A little bit about me. I am the founding attorney of Beacon Disability. I exclusively practice federal administrative disability law, and I can assist clients in all 50 states at agency level, SSDI, and SSI matters. So the Appeals Council is the final step. At agency, it's the final step that we might be able to assist with. So if you have questions about it, feel free to reach out, give me a call, send me an email. All that contact information will be at the end of the webinar. It's also below if you would like to click a scheduling link. On the replay, it's not below on the live, but on the replay, it'll be below in the YouTube description where you can easily click and schedule. On the live call, we'll go ahead and put it in the chat. So that way, if you do have questions, write them down as we go through. Click that link, schedule a time. It'll be a 15-minute time slot where we can discuss the questions that you've got, and I might be able to help point you in the right direction. So first, again, as always, I like to go through the 5-step evaluation process that Social Security uses for the cases, because it lays a good foundation and a good groundwork for you to understand a little bit about where Social Security is coming from. So the first thing Social Security looks at is, are you engaging in substantial gainful activity? Which currently right now is $1,350 a month, $1,350 a month in gross earnings, or if you are working more than 20 hours a week. If you meet either of those prongs, Social Security will deny the case at step 1. They won't even get into the medical records because they'll say you are earning substantial gainful. You are substantially gainfully employed. You're engaging in substantial gainful activity. By definition, you cannot be found disabled. If you are not earning gross of $1,350 a month or working more than 20 hours a week, Social Security will go to step 2, which is, do you have any severe medically determinable impairments? If not, again, the analysis stops there. Social Security says you can't be disabled because you don't have any severe medically determinable impairments. If you do have severe medically determinable impairments, the evaluation will move to step 3, which is, do you meet or equal a listing? Social Security will evaluate your case, evaluate your medical records, and determine initially, do you meet or equal one of the listings that are available in the Social Security Blue Book? If you do, the evaluation stops there and you will be found disabled. You'll get your favorable decision. You probably wouldn't be watching this webinar. If Social Security says you are not disabled because you don't meet or equal a listing, then they go to step kind of 3.5. And they create a residual functional capacity for you. They evaluate and determine, based on the medical records, what they think you're physically capable of doing. How long can you stand, sit, walk? How much weight can you lift? Can you do postural limitations? Can you climb, bend, stoop, kneel, crouch, crawl? Can you climb ladders, ropes, and scaffolds? What about your ability to interact with others? Can you interact with coworkers, the general public, supervisors? Can you stay on task? Can you handle a fast-paced production system? They'll evaluate all of that. They'll create an RFC for you and more. They'll create an RFC for you. And then using that RFC, they'll determine, can you go back and do your past work? If you can go back and do your past work, the case evaluation stops there. You're found not disabled. If you cannot go back to your past work, Social Security will go to step 5 and see, all right, is there any job that exists in the national economy that you could do? If there is, often you're still found not disabled, and that might be why you're watching this webinar. If there is no other work you can do and you can't go back to your past work based on the RFC, that's where you get a favorable decision. Okay. So what's different about the judge's denial? If you've gotten the judge's denial, you will look at it and you will immediately see that it's more detailed. It's not just a 1.5-page form letter that just says, here's the records that we looked at. You say you're disabled because of this. We say you're not, which is essentially what the initial and reconsideration denials often are. It's just a very short and sweet form letter that gets replaced, of course, with your specifics on your specific medical records, your specific conditions, maybe your specific past work. But generally speaking, it's a very short and sweet form letter. It doesn't give a whole lot of detail, a whole lot of knowledge on why they denied that case. The judge's denial will. The judge's denial will go through, it will specifically cite to certain medical records, it will specifically talk about your past work, it might talk about what some of your responsibilities were, but it's much more detailed. It'll often be, for an unfavorable decision, 10 pages or more. It can, of course, be shorter. It depends on how much medical evidence you have, but it's much longer, much more detailed than the first 2 denials you received. The ALJ denial is also different because it comes after you have a time to explain to Social Security why you think you're disabled. At the initial and reconsideration stage, sure, you might have had a conversation or two with the adjudicator. You likely filled out an adult function report, a pain questionnaire, an anxiety questionnaire, a cardiac questionnaire. You've likely filled out that kind of documentation and sent it in, but the hearing stage is different because you have about 30 to 60 minutes of undivided time that a Social Security Administration employee has set aside for you to talk to them. That 30 to 60 minutes is your time. The judge is focused on you and your case. And so it's a little bit different than when you have those brief conversations with the adjudicators at the initial and reconsideration stage. It's just set up very differently. And finally, judges are given great latitude. The appeals council appeal is a little bit different in the other 2 appeals, as at this point, you're trying to show that the judge's decision is wrong, and that it's wrong based on errors of fact or of law. And so the judges are given great latitude in picking what kind of evidence they want to support their position. And they have to explain often why they choose that evidence. And they're given great latitude in making those decisions. So the ALJ decision can be tough to overcome. Not impossible, but it is tough, but they do make mistakes. They're all human. So fast facts on an ALJ denial. It's not a bench decision. If you've watched a couple of other webinars or videos, you may have heard about a bench decision. A bench decision is where the judge tells you that day what they're going to do. If they're going to deny your case, they often don't tell you that day after the hearing, I'm going to deny your case. They will sometimes, depending on where you are in the country and what judge you have, if they're going to find favorably, they might tell you in the hearing that that's what they're going to do, but they don't usually tell you in a hearing that they're going to deny your case. They will just take the time, write the decision, and mail it to you. It is a mailed decision letter. And as I've said, it is often very detailed. It will include information about all of the evidence that was considered by the administrative law judge. You have 60 days to file an appeal of an ALJ denial, similar to the initial and reconsideration stage. And if you are disabled and unable to work, but the administrative law judge that was assigned to your case said you are not disabled according to their rules, you can appeal. Again, you are always given the ability at the administrative level to appeal unfavorable decisions. These decisions are a little tougher to overcome, though, than the others. So getting into how to file a request for review of a hearing decision. Number 1, you can file it online. This has become Social Security's preferred way. You go to ssa.gov, Or you can search, Social Security request for review of hearing decision. It's one of the first few that pop up on Google. Again, always, always, always make sure you are on ssa.gov. And that way you know that you're giving your information to the Social Security Administration, not someone else. So you can fill it out online. You can fill it out by using the Postal Service and Form HA 520, or you can submit it to them via fax, which again is that same form HA 520. Here is the form HA 520. As you can see at the top, you'll go ahead and you'll put your personal information. You'll put your name, your social, your claim number if it's different than the social, and then the reason you are requesting a review of the judge's decision. As you can see, there's not a whole lot of space there. You just kind of keep a short and sweet answer. You can, of course, attach additional documentation explaining why you are appealing, or you can check that little box there that says, please grant me an extension of time to submit evidence or argument. And if you check that, the appeals counsel will generally send you a letter saying, okay, we'll give you 25 days to get that additional evidence or argument in. Okay, that additional evidence can be a legal argument, why you think the judge is wrong. It can also be additional medical evidence that was not considered by the judge for whatever reason. The appeals counsel does have kind of strict rules around what it will and won't consider, but you can have that extension of time. Finally, down at the bottom, you'll go ahead and you'll put your contact information, including your signature, your address, your phone number, all that good stuff. Once you've submitted your appeals counsel appeal, your request for review of the decision hearing, the hearing decision, the Social Security Administration will review that decision. As I said earlier, they are looking for errors of fact or errors of law. At the appeals counsel stage, there is not additional testimony taken. You don't submit additional written testimony. You don't submit additional spoken testimony. The appeals counsel doesn't often send you the pain questionnaires and the supplemental questionnaires the way they do at the initial levels. The evidence is in at this point, and the appeals counsel is just looking at, did the judge make errors of fact or errors of law? They don't request additional updated records, but they will, similar to all the other stages, send the written decision in the mail. All right, how can an attorney help you? At this stage, throughout the entire process, including this stage, an attorney can provide guidance on what correspondence from Social Security actually means. Sometimes it's very hard to understand, but an attorney has seen this time and time again, and they can usually explain to you what it means. An attorney, if you contact them in enough time, can also file the necessary appeals and review your medical records and case file. So there's not a whole lot that an attorney can do, but they can be very helpful because, as I said, once you've got that judge's decision, it's tough to get it overturned. And so an attorney who knows the laws, knows the rules, knows the regulations can be helpful in making that argument to the appeals counsel on why the judge's decision should be overturned or sent back down for a second look. At all of the stages, except the appeals counsel, the attorney can help review your documents for accuracy and completeness. They can discuss what Social Security is looking for in their requested forms. Again, that doesn't really happen at the appeals counsel because the appeals counsel doesn't really send additional forms. An attorney can work with you to provide relevant updates to Social Security throughout your claim. They can still do this if you move. They can keep that information updated with Social Security. But as far as new updated medical records and new conditions, that isn't as critical of a thing at the appeals counsel level. It can sometimes, under very limited circumstances, be considered, but by and large, that happens at the lower levels. Again, at the lower levels, the attorney can help prepare you with a hearing before an administrative law judge, and they can also question you and any witnesses during your hearing. As promised, here is the contact information for me. Give me a call, send me an email. We did put that link to contact in the chat in the live webinar, and on the replay, it will be down below in the description. So if you have any questions at all, feel free to reach out. This webinar can't consist of legal advice because I don't know your specific situation, but if you reach out to me, we can certainly have a chat and see if it's something that I can give you guidance on. Thank you so much for spending your morning with me, and I look forward to speaking with you soon.